Hello, today we are going to talk about Monongalia County Planning Commission, or MCPC, Subdivision Ordinance on Major Single-Phase Subdivision. Major single-phase subdivisions are subdivisions which are not exempt and involve more than 5 splits, including the parent parcel. In the example to the left, the parent lot is over 5 acres and is located on an area that is served water and sewer facilities. The developer is seeking to subdivide it into more than 5 lots. A developer can pursue a standard or a preferred design in this instance. In this example, we are depicting a single-phase standard major subdivision. A typical standard subdivision would likely create 13 lots served by 2 cul-de-sacs. Major subdivisions will be reviewed by the MCPC. The approval process will be managed by the staff. If a subdivision meets preferred design criteria, it may be eligible for expedited review, which we start to show next, which allows for some savings in time and extra incentives in lot per infrastructure. If, however, an applicant is not eligible or does not choose an expedited process, they must follow the process described in standard major single phase. Preferred development would encourage developers to work with staff to create MCPC-aided design and would qualify for expedited review for a single-phase development. Expedited major subdivisions will still be reviewed by the MCPC, and the approval process will still be managed by staff, but the review times and the waiting requirements are shorter because such subdivisions are following design that are familiar with the MCPC and staff and are known to meet planning criteria. If the application is eligible or elects to follow the expedited process, this process is described in more details in the guideline toolkit. We will step through the process below. Here we will show the advantages in site design offered by preferred design. In this example, the MCPC-aided design would create 34 lots, avoiding a large steep bluff on the upper right. It's in a growth area, so it creates a more interesting and walkable subdivision with access to expand to the back of the property, which is owned by the same owner. It avoids slopes, costs less to develop per lot, and creates more lots. It also allows more than one way in and out of the subdivision and makes a better transportation, safe, four-way design. It also includes the possibility of a stoplight, which makes it more doable. Now to the application process. The first step is usually a sketch plan, which is optional unless for expedited, but strongly recommended for any major, especially if it's a first-time applicant. This allows the staff to explain the process and vet ideas of the applicant before they encounter any significant expenditures like engineering. One of the principal benefits would be staff assistance to determine allowable number of lots and the most general layout for them. That way the applicant can verify if the lots proposed are buildable from a legal step, including appropriate percolation tests for lots not within an area served by water and sewer. It would be a shame to pay for design and engineering and not be able to build anything. Note, there is not a time limit for this step. Part of the process, familiarization, is walking the applicant through what they would need to provide for a subdivision application, which we will discuss further in a minute. At the sketch phase, it is informal and the staff works with the applicant to familiarize their ideas to better prepare them to apply. That is the concept plan step.
This is part of Table 6.1 of the Monongalia County Subdivision and Land Development Ordinance, as well as the guidelines and toolkit, which reference the documents necessary for a subdivision application. Staff would review this checklist with the applicant before they would start applying. This will enable a smoother process for the applicant.
After sketch plan comments have been made and any necessary changes have been made, a concept plan can be submitted. The staff will have 15 days to review the concept plan. Concept plan evaluation is optional by the MCPC with no time limit. Staff or the MCPC may submit the concept plan to DOH or MUB. This can extend the concept plan review another 15 days. This step is critical for a smooth review process because it engages outside entities like DOH, DEP, MUB, and the State Fire Marshal, if applicable, early so they are not put in the position to reject the application at the end of a long process after all of the work and engineering have been performed. This allows the applicant and the MCPC to move forward with reasonable confidence that their review process is consistent with these outside entities and that they are not forced to guess on their behalf. After concept plan review would be a pre-filing application submission. This is a formal filing and the application check. The concept plan step would have shown the applicant all of the information necessary for this application. When the applicant correctly applies for a subdivision, the application is accepted, and this begins the formal time clock. An accepted application is checked to ensure all forms are submitted correctly to accept the application for formal review. Note, this is not the same as completeness. That is the following step. The staff has 15 days to review and accept the application. Once the submission is accepted by staff, staff can immediately begin follow-through scheduling. The next step is a completeness check. This step is mandated by state legislation and is intended to ensure that the MCPC has all pertinent materials to address the unique complexities of any given site. For example, in one situation, traffic generation may be important. In another, the proximity to a steep slope or a school may be important. The MCPC has a maximum of 45 days starting the day of pre-filing application submission for completeness review. This is to determine the necessary information and ensure it is provided for appropriate plan review. Note, at this stage, if an expedited review were chosen, it could save up to 2 weeks of a 45-day process. The next step is the land development plan, which reviews the general information, layout of lot and general structure, number of lot, density, and so forth of the proposed subdivision. As this offers the public a chance to weigh in on the project, there must be a public hearing. During the MCPC completeness review, a date for the public hearing is set and must be properly noticed at least 21 days prior to the public meeting. The applicant must post a sign and the staff must post a notice in the newspaper regarding the public hearing. At least 7 days before the public meeting, the staff must post a report on the county website. The MCPC will review the general details, including any special considerations that arose during the completeness review. They will also weigh the information from the applicant, the staff, and the public. Then they will determine if the application meets the requirements of the ordinance. The MCPC may approve the land development plan, approve it with special conditions, or deny the land development plan. If denied, the applicant must start over or abandon the project. If approved, the applicant may advance to the next step, or technical verification of the project details, including engineering, called the tech review, which is performed by the staff. After the MCPC approves the land development plan, technical review or verification is delegated to the staff through resolution conditions during the public meeting. Staff then has 30 days to complete the technical review if all of the required materials have been provided as part of the land development plan submission. The applicant may elect at this time to produce the materials for the technical review submission, provided that the plat is recorded within 1 year. After all, the majority of the information and drawings are dependent on the approval of the land development plan. This affords the applicant the opportunity to finish these materials once the land development plan is approved, avoiding spending money of a lot of engineering that would be wasted if the submission was not approved. This could extend the technical review time by a maximum of 30 days after these materials have been provided. If during the review the staff finds it applicable to submit the design to DOA or MUB, final conditions and consent may be required and are considered part of the required materials for final acceptance during technical review, i.e. 30 days when those consents are provided. Note that for preferred design may undertake an NIF1 also before technical review is completed by staff. This is called a site work plan. This way the applicant can begin work on the site in areas that are not under review by outside entities like DOH and MUB. However, it does not allow a developer to begin construction or sell off. It does allow demolition, underground infrastructure work, grading, and other site work. Apart from getting a head start, it has additional advantages to allow the developer better site knowledge, e.g. finding a huge boulder that forces moving an internal road 5 feet, which would modify the design slightly before recording the plat. This avoids having to go through the process of re-recording a new plat and possibly having to re-review the application as a whole because of such an on-site discovery. With an NIF1, staff still has 30 days to complete tech review after all materials have been submitted. The next step is recording the subdivision plat. After technical review is complete, the subdivision drawing from the land development plan is then filed with the county clerk as the recorded plat. After filing with the county clerk, the applicant will proceed to an NIF2, which allows infrastructure construction and the selling of lots. Once the NIF2 is complete, the applicant will proceed to an NIF3 or 4, which allow the buildings to be built.